tort law is much more than a mechanism to achieve ex post compensation to victims. It is a meaning and knowledge-producing institution that has the potential to catalyze change and regulatory action, and tort victims are no longer passive recipients of wrongful behavior seeking compensation, but active participants in the construction of other regarding meaning and knowledge in our society.
All right, so welcome everyone to today's interview, where I'm very pleased to welcome Professor María Guadalupe Martínez Alles. Her work focused on tort theory, comparative private law, consumer law, product liability, and punitive damages. She is associate professor with tenure at the University of Denver Sturm College of Law. Her book, Torts and Retribution, The Case for Punitive Damages, was published last year with Cambridge University Press, and that book's going to be our focus for today. She also has various published articles on these and related topics, but feel free to add anything. But with that, welcome and thanks so much for being here, Maria.
Thank you, Troy. Thank you so much for having me. It is a pleasure.
Awesome. So yeah, as I said in the introduction, we're going to be focusing on this book concerning punitive damages. So to start, can you just give a bit of an overview of the book? What are some of the main topics that you cover in the book?
Yeah, of course, sure. So, Torts and Retribution offers a retributive theory of punitive damages across jurisdictions and is grounded in the concept of relational retribution. And so at the heart of the book is basically a rethinking of the classic justification for punitive damages, moving beyond what are the dominant deterrence-oriented accounts of the institution to emphasize instead the moral significance of the wrongdoing for the victim, and particularly with the focus on the role of the victim in seeking some sort of retributive justice through the articulation of tort law and the tort process. And so by framing punitive damages as a form of relational retribution, the book also goes beyond exclusive just deserved justifications for retributive punishments and highlights punitive damages' expressive function and particularly the capacity of punitive damages to affirm the victim's dignity and legal standing. And so I would say that its central claim of the book is twofold. First, that punitive damages are inherently retributive. And second, one key reason why punitive damages are retributive is that victims' motivations in pursuing them are fundamentally retributive too. But importantly, the book depicts victims as seeking punitive damages not primarily to secure just deserts or to inflict some sort of suffering, but as a means of denunciation and as a means of affirmation of their own moral worth. And so the main argument, I would say, boils down to the idea, to the claim that retribution in torts is relational. And this notion of relational retribution comfortably suits both the interpersonal structure of tort law and the proactive role that is traditionally allocated to the victim in tort litigation. And so by recognizing this interconnection between the defendant and the plaintiff, relational retribution offers, I would say, a more holistic account of retribution in torts, which basically acknowledges the necessary link between, on one side, the reprehensible character of the defendant conduct as deserving of punishment, and on the other, the rich, correlative, retributive motivations of the tort victim, who initially seeks the imposition of the punitive award for purposes, as I said, of condemnation and value affirmation. So ultimately, I would say the goal of the book is reconciling torts and retribution in a manner that responds to both the relational significance of the role of the victim in expressing condemnation and also to the importance of maintaining some sort of institutional modes of moral communication between the private parties involved in egregious, reprehensible, tortuous situations. And so significantly, the book is questioning the classic formalistic depictions of victims as seeking restoration back to the former state before the tort happened. No, this idea of allocation back, there is the classic framework in tort law. Instead, what the book does is to depict victims as seeking value-laden responses that capture the significance of the wrongdoing in a way that communicates the impact of those kind of reprehensible wrongs on the victims and the victims' complex motivations for resorting to tort law and the tort process for some sort of private redress. And so this reading of the tort victim, and I think this is an important part of the book, this reading of the tort victim as active participant feeds on insights from social psychology and social sciences into the true motives that drive people to punish reprehensible wrongdoing. So ultimately, I would say that the book's ambition is to contribute not only to rethinking the classic confines of tort law, but also to reconceptualizing tort law, tort victims, and the tort process as an integral part of the broader social and cultural context in which it operates. I think it might be perhaps helpful to briefly mention the main topics I cover in the different parts of the book, very briefly. So in developing this relational retribution account that I just mentioned, basically what the book does is in the first part, focuses on the historical and theoretical place of punishment in torts. And so basically what it does, it analyzes why punishment is historically and structurally an intrinsic part of tort law rather than a concept exclusive to the criminal law. And also in these first parts, what the book does is to evaluate the existing tort theory or tort law frameworks and tries to demonstrate that they fail to account for egregious wrongdoing that demand much more than compensation. The second part of the book, just having that background, the second part of the book moves into the core of the book, which is basically the concept of relational retribution and the development of the retributive rationale of punitive damages. And basically what this part of the book does is, first, it solves in a way the punitive puzzle by shifting the goal of punitive damages away from the dominant deterrence-oriented accounts, which basically do not respond to what victims demand when they file a punitive lawsuit. Then the second aspect of this part of the book, what it does is builds up the relational retribution framework. We probably we're going to discuss in more detail later on, but basically connects wrongdoer and defendant. And the third part of this second part tries to overcome the traditional legal mindset that tort law should only reduce injuries down to financial compensation. So tries to overcome compensatory reductionism. The third part of the book, it's moving towards a different context, which is mass market setting context. And there what it's trying to identify is how punitive damages are a retributive tool vis-a-vis corporate defendants, and basically try to grasp what is going on in the context of props liability and suggest some new directions that perhaps we will discuss later on as well, on how these might have some impact in the context of AI harm and new technologies. And the last part of the book moves to the institutional value of tort law. And there what the book does is to emphasize and to show the significance of the victim, in the sense that it emphasizes this proactive role of the victim in tort litigation and their legal standing, the idea of agency of the victims in this demand for compensation and value affirmation. And basically, it shows why victims are especially situated to be the ones to exercise this substantive power to be punitive. And it connects this with the tort process. It highlights why tort litigation is uniquely equipped to deliver this form of retributive justice compared to the criminal law and the criminal procedure, and why it makes sense to think of tort law not in isolation, but as an essential part within a web of other institutions that are in charge of assessing risk and harm in our society. Thank you.
No, great. That's a great overview, and we're definitely going to explore a lot of the different things you bring up there. I was just thinking, just as introductory point, maybe just to be clear, what would you say is it that distinguishes exactly punitive damages from other sorts of damages, like you mentioned compensatory damages, or other sorts of lawsuits that someone might bring forth, just to make clear for the audience what we're targeting here? Do you mind just giving a brief explanation?
Yeah, thank you. Yes, of course. So punitive damages are focusing on the idea of punishment, the idea of an imposition of a sanction, whereas all the other kind of damages are focusing on compensation. It's this idea that I mentioned at the beginning that the book challenges, which is the idea of restoration back, right? So the classic rectificatory framework of tort law, to which most kind of damages respond to, is this idea that what victim wants when they activate tort law and the kind of responses that tort law can give to victims are compensatory, are restorative. It means putting the victim back as if the tort didn't happen. And so this would be the main difference. And what punitive damages are doing is a different kind of work, because what they are shifting, they're shifting the attention to the character and qualities of the behavior of the defendant, and not necessarily, as all the other kind of compensatory damages, on the impact of the wrong on the victim. No, whether it affected the property, their health, whether it affected their emotional well-being, their pain and suffering, and so on. So these are all the other categories of compensatory damages.
Good. Yeah, perfect. So I was wondering, could you talk a bit about the prevalence of punitive damages? Why do you think it's as common as it is sort of worldwide?
Yeah, thank you for that question. Actually, one aspect of punitive damages that caught my attention from early on was how punitive damages have persisted over the centuries, despite a strong resistance and frequent calls for abolition from tort scholars and policymakers. But clearly, abolitionists have failed in these repeated attempts to eliminate punitive damages, and clearly the support for maintaining punitive damages is strong in most common law jurisdictions, but not only in common law jurisdictions, because similarly, strong attempts to reject punitive damages in civil law jurisdictions have also failed, since punitive damages have been at the center of legal debates for decades in those jurisdictions, and are even gradually gaining recognition as well. And so what we can infer from this is that punitive damages might be doing something very important. And the insight here is that it might be that tort law would be a less complete institution without punitive damages. And that is basically the starting point of the book, acknowledging its prevalence and providing an understanding of what that significant role might be. And here I would like to mention something that I mentioned at the very beginning in the book, which is this idea of the significance of the exceptional. And why I want to mention this, because even though punitive damages are prevalent, they're also exceptional, right? And so many would think, well, but it's an exceptional kind of remedy. Why giving so much attention when in quantitative terms, they are not so much representative of of damages of tort law in general, right? And I want to challenge that idea because even when they are recognized as an exceptional remedy, I am really not sure that we should attach less significance to the exceptional cases than most to the regular cases. And why is that the case? Is because we're talking here about tortious behavior that involves reprehensible violations of substantive interests that have great social significance and that demand institutional responses that are able to match the seriousness of the behavior, recognize the significance of the interests that have been invaded, and that has also the potential to trigger some sort of meaningful conversation over what we owe to each other as members of the same political community, right? And so overlooking the importance of these relatively slim, if you want to call it, categories of tortious cases, just because they are less, is my understanding that risk mistaking the true value and the actual role of tort victims in our society. So, Torts and Retribution, I think it's an invitation to look at tort law more qualitatively rather than quantitatively, in a way.
Yeah, no, that's good. I see that, like, just because it might be exceptional or rarely handed out, that doesn't mean that there aren't cases where it's like deserved or appropriate. And so we should consider that at least, and not just say, well, it's so rare that maybe we should eliminate it altogether. I think that's,
yeah.
I mean, we might end up coming to some abolitionist conclusion, but it shouldn't be just because it's like would be rarely litigated if it were instituted. Yeah. Anyway, yeah, that's good. And then, yeah, so maybe could you go over some of the sort of main theories in the literature on legal punishment?
Punishment. Okay. Yes, briefly and broadly, since I'm not an expert in theories of the criminal law, and I have to say that. Okay. I try to, but in fairness of the criminal law theorists. But I would say that we could think of, in broad terms, of let's say a standard deontological justification and perhaps a consequentialist one, because this is the framework that Torts and Retribution keeps in mind in order to develop the idea of relational retribution. So I would say that the standard deontological justification for punishment is the one that is more broadly associated with the retributive or just desert rationale, according to which punishment should be meted out in proportion to the seriousness of the wrong committed. And under this more deontological rationale of punishment is a morally justifiable end in itself. And basically a principle that is a corollary principle of retribution is that of moral proportionality. And so basically the principle there holds that punishment should reflect the degree of moral offense caused. And so this means more serious crimes hence deserve more serious punishment. And basically looking at the offender's intention, the magnitude of the harm are kind of like the two key components of this sort of rationale. Then we could think of another competing justification that is built, as I said, on a more consequentialist theory, broadly associated with welfare maximizing or some sort of utilitarianism. This idea that society is composed of rational, self-interest individuals, and this is more the deterrence rationale of punishment, according to which the aim of punishment is reducing the frequency and likelihood of future offenses. And so basically this understanding holds that the punishment of an offender should not exceed what is sufficient to prevent future instances of the offense. And so this deterrence rationale, I would say, is grounded on the assumption that potential offenders act rationally by weighing the extent and likelihood of the benefits and risk of wrongdoing prior to such acts, and that the prospect of punishment changes the result of this cost and benefit analysis of the situation, ideally making the criminal activity pondered and attractive, right? Or basically, to put it differently, punishment induces people to perform ex ante cost benefit analysis that, if the punishment is severe enough to outweigh the potential gain, will inhibit them from doing future harm. And so, under this deterrence rationale, I would say that the most relevant factors are the frequency with which the specific wrongdoing happens and the detection rates. And so, when it can be deduced that a certain type of wrongdoing is rarely detected, then it should be punished more severely. So these would be briefly the two main accounts of legal punishment.
Good. Yeah, I probably should have asked more specifically in tort law, but yeah, fair enough. Good. Yeah, I did.
Well, I am trying, right, to offer a dialogue between tort law and criminal law. So
right. Fair enough. One thing that I was thinking about, and it's something that comes up in my response to like a lot of different things. So it's I make similar remarks in a lot of the interviews that I do on here, is that I often think that these sort of relatively simple kind of unified theories of the target phenomenon, in this case, retribution, they're sort of doomed to fail, right? And primarily because the target phenomena, what we're trying to capture, is somewhat messy, variable, not super precise, vague, and so on, and sensitive to various factors. What do you think about this in this case when we're thinking about retribution and related notions and tort theory and law generally?
Mm-hmm. Yeah, thank you. Thank you for that question. Yes, I mean, the thing is that what I try to do, I think it is that I realized that it was difficult to come with, like, as you said, a clean, simple theory of retribution. And so the way I look at the problem was trying to figure out what criminal law theories had been discussing and doing about retribution, because of course you can find much more developed accounts in the criminal law than in the tort law, right? And so when I look at that, what helped me think of a theory of retribution that might be perhaps more helpful in the context of tort law was identifying that what I thought was missing in those theories of retribution was that the focus was exclusively on the offender and on deservedness. And that in doing that, those theories ended up overlooking the significance of the wrongdoing for the victim, and at least in the relational way that the bilateral structure of tort law can provide. So what I thought is that the theory of retribution that I can offer in the context of tort law, it's based on this bilateral structure. It's based on this connection between the victim and the defendant, and how this can be somehow channeled and happening in an institutional framework. And I think this gives some context, gives some institutionalized rules that might, or I think, make people feel about retribution in a less messy or less variable way. And so this is kind of like the way that I approach this problem. But I mean, I don't think I have like a clear answer to that, because still, I think, well, we probably are going to discuss later on what's going on with victims' motivations, why they're important, why we should care about them, why the law should care about them. And these are all very valid questions. But I think grounding a theory of retribution within an institutional framework and mechanism might help address or grasp the theory in a more, or in a less, if you want to call it, messy way. And I hope I can do that.
Right. Fair enough. And that also leads me to think, because like in certain contexts, and maybe especially in law generally, or in tort law in particular, we might want, well, we don't want it to be sort of messy and super contextual and unclear.
Yeah.
Like so maybe we might be disposed to kind of like precisify it in a certain way, or some people talk about sort of conceptual engineering or development rather than just maybe a descriptive project of describing, say, what we're getting at or what we have in mind generally when we employ these terms. So what do you think about this? Do you see the project here as partly this sort of engineering project, sort of refining or developing these notions in a way that's maybe beneficial in law or more generally to be more precise or clear or something like that? Or what do you think about that? Or do you think this is a sort of reasonable framing of the project?
Yeah. Well, I mean, I would say that at the core of the book is the idea that in order to revise our concepts and practices in a certain way, we first need to understand what those concepts and practices are. And why I mention this, because this is particularly relevant in the context of punitive damages, where the concepts of retribution and deterrence, these are like the declared, widely accepted double function of punitive damages. These two concepts, retribution and deterrence, have suffered for perhaps too long from under-specification and have stayed at a level of abstraction in the discussion. And so, even when we can say that the retributive roots of punitive damages had been acknowledged by courts and commentators since the very beginning of the common law of torts, the book shows exactly that there is this consensus on punitive damages double function of retribution and deterrence. However, most of the time, it is unclear what legal actors and scholars mean when they refer to these concepts. And so, to answer to your question on reconstruction and engineering, I would say, yes, the book can be read as offering a reconstruction of that fundamental retributive rationale of punitive damages, because the dominant scholarly focus has so far been elsewhere. It has been on the deterrence dimension of the institution, dominated by mostly law and economics accounts of optimal deterrence, and the retributive angle of the institution had been relegated somehow. And so the book identifies this mismatch between a purely oriented deterrence reconstruction of punitive damages and their retributive roots that had been somehow relegated. And on that basis, is trying to offer a normative justification of retribution in torts. And so this is the way that the book is offering to understand the concepts and practices, and perhaps it's the starting point to challenge them and to continue thinking about them. But I think this was missing. It was missing offering what are we talking when we talk about, when scholars and courts talk about retribution and talk about deterrence. And so, yes, that is how I would read the project.
Good. Yeah, I see that for sure. Like, there's going to be some sort of developmental or engineering aspect to it, but it shouldn't be too disconnected from existing concepts and practices and desires and intuitions and things like that. So there's some sort of descriptive or empirical work that's sort of required there to figure out sort of where we're at and like what's going on already. And then maybe you can go on and recommend some further development or refinement or something like that. That makes, and these sort of things can work in tandem. That makes sense to me. But so on, partly on that thought then, so regarding some of the common motivations in favor of punitive damages, you argue that things like deterrence tend not to be the main factor, but more things like retributive intuitions. Like these are intuitions that people should have to pay for their wrongdoing, more than just what's would be compensatory, like to receive like a deserved punishment. So maybe could you talk a bit more about this and why you think this is the key factor here, and in particular in the book you talk about certain empirical findings. Maybe if you could talk about that a little bit more and how that relates to this.
Yeah, thank you. Yes, under dominant deterrence-oriented accounts of punitive damages, tort victims have been depicted as contingent agents, as rational agents that are filing the punitive lawsuit as kind of attorney general, playing kind of like a private enforcer's role in the name of economic deterrence, right? So this is kind of like the depiction under the deterrence-oriented rationale. Once you start looking at, I think you mentioned, if I could mention empirical studies, once you start looking at what are the true motives that lead people to file a punitive lawsuit, their empirical studies tell you that deterrence doesn't play a prominent role at all in the victim's motivational compound. And so what they show is that the imposition of the retributive sanction is understood by the victim or as an opportunity to send a condemnatory message or as a vehicle to get to know what happened to them. And this is very interesting because there are a lot of empirical studies in the context of medical malpractice where when victims in interviews, they express that what they want is to know what happened to them, to know what happened to their bodies. And the only way they have to know is by filing a tort lawsuit, is by asking, identifying who was involved in the torts as well. And so this, I think, is a very interesting insight. Other studies say, well, it's a public forum to voice the moral significance of the wrongdoing, to express what it means to be wrong in a diminishing or humiliating way, and an affirmation also that justice and equality matter in our society. Other empirical studies say victims file lawsuits because they don't want this to happen to other people in the future. And so they want to be some sort of, and this is something very important for the book and for relational retribution, some sort of active participants in some sort of change moving forward. And so when you look at all these motivations, deterrence, at least deterrence in these exclusive economic terms, doesn't play much of a role at all. And so that's why the focus on retributive motivations, I think it's powerful. It's powerful because it shows what victims want when they file a punitive lawsuit. Perhaps, Troy, can I add one element here as well to clarify? Yeah, to clarify a little bit something that it's very important, I think, and tends to be overlooked, is that when I look at these retributive motivations, they come together under the concept of relational retribution, and there are two elements that are involved here. One is the deservedness that is connected with the retributive motivations, and the other is the recognition of the victim's equal value, the idea of value affirmation and the idea of self-worth. And so what these retributive motivations are capturing and the relational retribution is these two elements. So it's not only about retribution in the deservedness terms, but also in terms of recognition of the victim as an equal value, with the equal value of the victim, the self-worth of the victim. And basically these two elements come together in what is the victim's substantive power to be punitive.
Right. And we'll explore the relational account a little bit more shortly, but I want to ask a couple more things before we get into that a bit more. First, you discussed some of the punitive intuitions and stuff. Why, like, how seriously do you think we should take some of these more, say, emotional responses? And it's something you discuss in the book, because we might worry that they aren't rational, or at least aren't wholly rational. So maybe we shouldn't sort of base our tort law or legal theorizing in large part, or even a little bit based on those. So I don't know. What do you think about that, and why don't you share that concern?
Yeah. Yes, thank you so much. I devote a whole chapter, right, to the rationality of emotions, exactly because of your question, because I understand that this is something that very, very important to address, because it is an understandable concern. No, is this concern that emotional, intuitive responses might be irrational, and for that very reason, the law should disregard them, right? And so, what I try to show in the book is a little bit first reject this classic polarizing narrative between reason and intuition, between law and emotions, as if they were totally opposing poles. I challenge that idea. And I argue instead that this might be a rather simplistic understanding or representation of what is going on. No? And I think there is much more to be said about those relationships. And so basically, the point is that intuitive or emotional responses are not necessarily rational. They just respond to a different kind of rationality. And I'm very much interested in this discussion because it's not that they're irrational, it's that it is about our ability to reason intuitively. And this ability to reason intuitively calls for a different kind of rationality than the law is used to deal with, in a way. And so, for example, it would be odd that not to feel outrage at a callous defendant who deliberately wronged us in a humiliating and diminishing way. We would say that these moral emotions, these intuitive emotions have an important other regarding meaning in our society, and that they say something important about the way that we ought to treat one another, right, in our society. And so it might be that they are not always out of control and irrational, and also there are ways in which, if they are disproportionate or out of control or irrational, ways to correct them if, for example, the underlying assessment of the situation was mistaken or erroneous. So it was not a deliberately wrongdoing. It was a total and deliberate mistake. So these can change these intuitive responses. So, of course, this doesn't mean that the law should always account for emotional responses. It doesn't mean that. The legal system, I agree that the legal system is not there to track people's intuitions about appropriate conduct and to respond to them. The legal system is there also to mold intuitions and behaviors and so on. But sometimes it may be apt for the law to operate, I think, in a manner that is more consistent or at least sensitive to intuitive beliefs and reactions of the members of the community. Other times, it is not. It is not the case. And so this is the invitation of Tort and Retribution. My invitation is we should collectively decide which mismatches matter and which ones not. And so to be able to do that, we first must acknowledge and evaluate the retributive motivations that shape our punitive reactions. And basically, that's my point. Before deciding, no, we should ignore them, we should just reject them outright, retributive motivations as some sort of a across-the-board policy in order to avoid the stigma of, let's say, embracing some sort of revenge or some sort of emotional rationality or deforming the equilibrium of the legal system, because that's the fear. I think we should first seriously evaluate whether and to what extent and under which circumstances it would be proper to integrate retributive motivations into tort law and when it not. And so just to close my answer, I would say that why, I think you asked me why I do not share that concern or this concern. And I would say because I could make sense of retributive motivations in a way that enables, at least in my view, a systematic understanding of their place in tort law. And so what the book shows, I think, is that victims' retributive motivations for punishment in certain cases of egregious tortious behaviors, they follow a logic and a structure that not only is completely different from revenge, but also that is appropriate in these instances of reprehensible wrongdoing. And also, I think the book shows that tort law and the tort process can play a they are like the institutional mechanisms, the institutional channels that can play a very fundamental role in capturing, in channeling, responding, and especially in controlling them. And so I think that what is important, and is something that is underlying the book's argument, is to provide, I mean, if we care about people's ability to engage meaningfully with their peers, I think we should ensure that people have available, legitimate, official channels for institutional expression. And tort lawsuits are one of those. And this is what worries me, to provide these channels. Otherwise, we might risk intuitive and emotional responses backfiring. And this really worries me. So channels, institutional channels, might be, and more important than ever, to think on how to provide them.
Good. So I take one of the key points there was that, look, there can be cases where these intuitions or motivations are inappropriate or disproportionate, but there are cases where they're appropriate and proportional, right? So and we need to take them seriously, or it makes sense to take them seriously when in theorizing about punitive damages, in some cases at least. Does that sort of capture part of the key issue there?
Yeah. To add to that point, Troy, the importance of having an institutional mechanism to channel these intuitive responses to wrongdoing, it's important because what you have within, for example, the tort process is you have in place rules, procedures, standards of proof, and other mechanisms that provide a check or control on those intuitive responses when they are not proper or when they aren't rational in a way. And so that's why I don't share so much that concern, because I think we can control them if they are channeled in an institutional setting that follows rules and rules of procedure and so on.
Right. So then, the main point there is that the fact that there can be some irrational or disproportionate responses that could be controlled by the system that has sort of checks and for these sorts of things. Yeah, of course, that makes sense. Of course, that doesn't mean it's always going to be easy, but I mean that it's something you should.
Good point.
Yeah, good. And okay, so you've been leading up to your relational retribution account. There's other approaches that you think are ultimately deficient in various ways, and this is partly why you end up with your preferred account. But do you mind sort of talking about some of these other approaches and why you find them deficient first? So like kind of a pure vengeance account, or just desserts account, an expressive defeat account. Maybe at least briefly introduce those and why you think they're not going to be sufficient as accounts of retribution and torts.
Yeah. Yes. Well, surprisingly, when you look at the justifications, at the available justifications of punitive damages in tort theory and in tort scholarship, you can find very few retributive reconstructions of punitive damages. Again, for what I mentioned at the very beginning, right? The focus has been perhaps too much on the deterrence rationale of the institution. So there aren't many retributive reconstructions, but the few that are available are insufficient in my view. And why they're insufficient? Because some of these theories are thinking, have fashioned in a way punitive damages as an instrument to regulate the wrongdoer. So they haven't moved the attention from the perspective of the behavior of the wrongdoer. So they consider them as an instrument to regulate the wrongdoer. They divert the attention away from the tort victim, who it's very important in the relational retribution because it's the one that is ultimately deciding, to file, to initiate the tort process and to demand the imposition of the punitive award. And so basically, those reconstructions. Basically, what they are doing is considering punitive damages as a scheme of retributive justice committed to condemning misconduct in the public's name rather than the victims. And so instead of focusing on the private plaintiff vindicatory interest, punitive damages under these retributive theories instead are considered to be the public interest or to respond to the public interest in retributive justice. And so what I'm trying to say about that is that punitive damages under these theories function like the criminal law does, mostly focusing unilaterally on the imposition of punishment on the wrongdoer, and mainly they are conceived as some kind of outsourcing mechanism from the criminal law in which tort victims are again represented as contingent participants in the practice who demand this imposition of punitive award on behalf of the state somehow. And so these accounts take the focus away from the victim and places the focus almost exclusively on regulating punishment for wrongdoers. And so they are not helping us in considering the victim's perspective. The victim is not considered in this kind of retributive retributions developed in tort law. And then the account of expressive defeat is very interesting because it was the account that actually made me think about the topic at all, in a way. But when I started looking in much more detail, I realized that, again, this account of expressive defeat, the big victims are disconnected from their role in bringing about the expressive defect, in that they are conceived to the most part as instrumentally, as private enforcers again. And so regulating the wrongdoer thus becomes the focus once again, with the idea that punitive damages correct these kind of undesirable social behaviors, and consequently largely absent in this kind of reconstructions are justifications that victims are especially situated to be the ones that demand the punishment from the wrongdoers, or for why victims should receive the punitive award directly from the wrongdoers. They cannot justify that. And so these early retributive formulations of punitive damages are vulnerable because of these reasons that I just explained, and have been heavily criticized because they cannot actually justify the fact that the victim is the one receiving the punitive damages, and they cannot justify why the victim at all is the one that is asking for the punitive awards. So basically, to sum up, what the available theories of retribution in tort law show is the disconnect between wrongdoers and victims, and they cannot justify this connection that is typical of tort law in a way, and also they somehow stayed in the same narrative or understanding that this is a kind of a unilateral, exclusively focusing on the behavior of the wrongdoing kind of thing.
Great. So, okay, we should spend more time, although you've talked about it a bit already, your relational retributive account. Maybe if you laid that out a bit more, and then talked about how you think that solves some of the deficiencies that these other approaches have faced. So yeah, could you talk about that a bit?
Yeah, thank you. Well, yes, relational retribution, basically what it does is, in my understanding, offers a more holistic account of retribution in torts, because it recognizes this connection that I just mentioned, no? The connection between the reprehensible character of the defendant conduct as deserving of punishment, and on the other hand, the perspective of the victim. So these rich correlative retributive motivations of the victims of these seriously disrespected actions, who are seeking the imposition of the punitive award. So basically, relational retribution, what it's offering is a wrongdoer victim perspective, and basically what it's doing is including the victim in the equation. And so once we, through relational retribution, once we start to dig deeper into the victim's retributive motivations and try to establish this relational dimension or this connection, what relational retribution does is to show that retribution, only conceived as just desert, no longer seems an accurate representation of what tort victims seek when they file a punitive lawsuit. And here is where the idea of denunciation and value affirmation comes into the picture. Relational retribution is a combination of deservedness and recognition, or if you want to call it, deservedness and value affirmation from the victim's perspective. And so basically, what we can see of what relational retribution help us to understand is that when a defendant commits an egregious wrong, they basically are sending a message that the victim's right or that the victim value is that the victim is of less value than the wrongdoer. No, it's this balance between the parties, and the punitive award acts as some sort of public denunciation and as a way of stripping the wrongdoer of that false idea of superiority, and in that way reaffirming the victim's self-worth. That's why it's important that these two elements are interconnected for relational retribution. Deservedness and recognition come together. It's not only about the imposition of a punishment in just deserved terms, it's also an imposition of the punishment that allows the victim to reclaim her dignity, her value affirmation. I think this is one of the main contributions, in a way, of relational retribution and the link of the parties.
Good, yeah, that makes sense. I mean, I kind of like that, how it sort of ties the punitive aspect to the defendant with the, I don't know, restoration of dignity or some sort of benefit to the victim, rather than just focusing on one of those things or treating them as independent. I sort of like that as an approach. It makes sense to me anyway. But yeah, no, that's good.
I forgot to mention why I think it's a better approach. I think you asked me that. Or
yeah, fair enough. I mean, you've sort of already been talking about that a bit, but if you wanted to focus on that a little bit more, yeah.
I can if you want.
Sure.
Perhaps I would say that 4 points or 3 points might be important. And one of those, I think we mentioned already, is that it offers a normative justification of punitive damages that aligns better with the retributive roots and with the victim's motivations to file punitive lawsuits. So somehow relational retribution, I would say, it outperforms deterrence of only models. Also, another thing which might be a better approach is that it solves the windfall puzzle, where we just talk why the victim is the one that should receive the punitive award. This has been the main criticism of punitive damages from early on, and relational retribution can offer an answer to that is connected to these two elements, in relational retribution and the reclaiming of the self-worth and dignity of the victim. And also, I think relational retribution challenges this assumption that tort law is about restoration that we mentioned at the very beginning. And it also shows that delivering punishment through tort law might make tort law a more complete institution and give a more complete answer to the victims. And so the insight here is the law of torts would be less complete institution without punitive damages. And I think relational retribution shows that. And the last element, which I think is very important, is it offers a new reading of victims as agents. And this is core for relational retribution because it treats traditional torts tends to treat the victim as a passive recipient of wrongful behavior seeking compensation or restoration. And what relational retribution does is frames victims as active participants, as agents who are using the courts to reclaim their self-worth and to send messages of other regarding meaning. And so this reading of the tort victim, I think it fits very well with the bilateral structure of tort law and also fits well with the classic protagonist or active role of victims in tort litigation. So I would say those are some of the main factors why of what relational retribution is bringing to the discussion.
Good. Yeah. That's a good summary there for sure. I like that. So one of the things you talked about a bit earlier was opposing this response of sort of eliminating or folding punitive damages into other things like compensatory damages. And one thing that you discussed a little bit in the book that I found interesting was that, in some jurisdictions, for example, in English law, there are things called aggravated damages. And so maybe if you want to talk about that a little bit and where do you see the distinction between punitive and aggravated damages, and how sharp is that distinction, and how might you apply your relational retribution account in that sort of case or in that sort of jurisdiction?
Yeah, well, thank you very much for that question. Of course, it's a tricky question because this is a debated issue in the English common law, in the sense that, of course, aggravated damages are mostly understood by English law scholars as compensatory damages. Even though, I agree that the borders between punitive and aggravated damages are quite blurred, I would say. And so you have a minority of English law scholars who actually recognize that the lines are more blurred than not, and that recognize that aggravated damages are basically punitive damages. So all this discussion is in the background between punitive damages and aggravated damages. And what you can see is that very few jurisdictions have aggravated damages. No, this is not the case in the US and so on. And it might be because of that. It might be that because aggravated damages are actually punitive damages under a different label. But of course, this is a more complex discussion that is actually still going on. But what I would say is that what aggravated damages, understood as compensatory damages, are trying to do is to respond to the aggravation of the victim's dignitary interest. And so basically what aggravated damages are doing is pointing out that the reprehensibility of the wrongdoing had aggravated the victim's dignitary interest. And so to give you an example, if someone insults you, but then spit in your face, is aggravating the dignitary interest. So the insult is already a violation of your dignity, but if you add the spitting in the face, this aggravates that. But the problem I see with aggravated damages is the focus. They're focusing on the impact of the wrong on the victim, on the aggravation of the dignitary interest, of the violation of the dignitary interest of the victim, and not on the reprehensibility of the defendant's conduct. And so what I argue in that sense is that aggravated damages are not helping us to distinguish punishment from compensation. Actually, what they are doing is diluting the expressive angle of punishment, and also are making proportionality, which is something very important when you apply punishment, very difficult to apply, because they are not clearly sending a message that concerns the quality or character of the defendant's conduct. They are just focusing on this aggravation in the impact on the victim. And so that's more or less what I try to show regarding aggravated damages, and to show why it's important, because basically this is the core of Torts and Retribution, is to argue that it makes sense and that it is important to distinguish punishment and compensation and to treat them as such. When we are compensating, we have certain rules and certain focus that we have to follow. When we are punishing, we should care about other things. And so we shift and pay attention to the defendant's conduct. When we quantify, we have to consider proportional sanctions and so on. And so it's not the same thing And it is important to be transparent and to distinguish when we are doing punishment, when we are doing compensation. And I think most legal systems would say this is fair to do, right? So we don't want a legal system that is punishing in a cover or hidden way. We want rules, and we want to know that we are punishing, and we want to give both parties the possibility to defend themselves, to protect themselves. And that's why we might be discussing about different standards of proof and so on. And so this is kind of like the main aspect that I try to show on why aggravated damages, they do not respond to relational retribution in a way.
Right. So the key point there is that they seem to focus more on the impact on the victim than, without really taking into account sufficiently the sort of wrongness of the defendant's action of their torturous behavior. So as a result, maybe in practice it's somewhat similar to sort of punitive damages, because maybe it's going beyond just what we might think, like what an appropriate compensation might be, but it's not really the punitive damages or retributive damages that you want to talk about. So you want something more that also focuses on the wrongness of the act and takes that into account.
The message that they communicate is different. They don't communicate a clear message of reprehensibility of the defendant's conduct because of what you just said, because they are focusing on the impact on the victim. And so the message, if you want to call it, is blurred regarding the reprehensibility of the conduct. And this is what is the main aspect of punitive damages. If we are punishing, we want to clarify for which kind of conduct we are punishing, and so on.
Do you think in practice, like if they say in English common law, if they modified their aggravated damages to function more in this way, do you think a lot would change in practice, or just in like how it's presented? Like, do you think maybe the damages would be more extreme in some cases, or what do you think?
Mm-hmm. Yes, I mean that's a question that I think I have had some discussions with English law scholars, and they say, well, both punitive damages and aggravated damages are very rare and very exceptional, and the amounts of compensation are quite low, and so I think probably won't change that much in terms of amounts of damages, maybe a little bit, because you will be distinguishing what is compensation and what is punishment. But I don't think it will, in practical terms, change in terms of the amounts of the compensation. Conceptually, yes, because of what we just discussed, and also keep in mind that. Surprisingly, the English common law is the jurisdictions where punitive damages are restricted the most. And so they are only available for certain categories of cases. And even other Commonwealth jurisdictions are much more are broader in their availability of punitive damages. So we are talking of jurisdictions where punitive damages are already quite restricted in their application in any way.
Right. Okay, so we've been focusing basically on sort of interpersonal wrongdoings and how those can result in punitive or retributive damages. But you also in the book talk about so-called mass market wrongs. What are mass market wrongs, and how would you say that retributive motivations vary between those sorts of wrongs and sort of the standard interpersonal wrongs?
Yeah. Thank you for that question. What I try to do, because the focus of, my focus has been on retributive motivations, and what I want to do is to account of retributive motivations in the mass market context. And so why is that the case? Because punitive damages are regularly imposed on callous corporations, so this is juridical persons, for marketing defective products in wanton disregard for consumer safety. And so when I'm moving into what I call this collective context, this mass market context, what I'm trying to do is trying to grasp how punitive damages, how retributive motivations come into being in the context of the manufacturer-consumer relationship, and particularly, it's not exclusively, but particularly in the context of prox liability. And so what we can see, what we can observe, to your question of what is the mass market or which kind of wrongs or torts I am thinking of, basically what we can identify in the mass market context is a pattern of conduct, which basically, in most of these products liability punitive cases, and basically it consists on the following. So first you have a defective product. Second, the defect becomes known, and yet the manufacturer decides not to correct it because the cost is deemed excessive. And third, the product is marketed as safe without disclosing the defect. And so basically these are these kind of like three layers wrongs that consistently take place in the marketplace in this kind of prox liability cases. And so this part of the book does is to show that there is a difference between the one-on-one context, which is, as you mentioned, the interpersonal wrongs or interpersonal tortious situations, when one individual directs the conduct to another individual, for example, a personal insult, defamation, or if you want to think of the more contemporary dignitary torts such as cyberbullying or online harassment. These are these kind of one-on-one context settings. And the collective context involves, as I said, these tortious situations that arise from what I call impersonal market transactions between consumers and corporations. And the typical example, as I said, is this deliberately sale of unsafe products as safe and for private gain, basically. And so what are the retributive motivations here, right? And so here, I offer, on top of moral outrage, that I think is a motivation that better explains the one-on-one individual context. Betrayal aversion comes into the picture in this part of the book because what I try to show is that these betrayals of trust in the mass market context better explain what is going on here, the dynamics between manufacturers and consumers. But I want to clarify something, which I do in the book, is that this doesn't mean that moral outrage and betrayal aversion cannot overlap. So they don't function or operate exclusively like in the individual context or in the mass market context. They might very well overlap, but what I think it's a special of betrayal aversion that explains this mass market context dynamic and why consumers develop these retributive responses towards callous corporations is the idea that betrayal aversion invokes an asymmetric power relationship between consumer and manufacturer, which is basically based on knowledge superiority and on technical expertise. And this not necessarily happens in, for example, the personal insult of defamation cases that I just explained. So moral outrage is not so much built on these asymmetric power dynamics, but betrayal aversion, it's much more connected to or built on that idea. So that's why I think this is the retributive motivation that explains why a consumer would want to file a punitive lawsuit against a corporation, a callous corporation.
But I had a couple of questions related to this. First, to what degree do you think consumers seek punitive damages for principled reasons, like value affirmation or condemnation? So I would think that it's probably maybe more mixed between those sorts of motivations, but also financial and vindictive ones. If they think they can get some payment or something from a suit against a corporation, then that might be part of the motivation there, maybe a significant part of it. So yeah, what do you think about this in practice?
Yeah. Thank you so much for that point. Of course, I mean, victims' motivations are complex, right? And so I don't think I'm arguing in any part of the book that we can just identify one motivation. And so certainly you have a point there. And sometimes the need for compensation will overlap with the need to be punitive in a way. Other times, the need to be punitive will predominate in the victim's motivational compound over the need for compensation, and vice versa. And also, there might be other motivations doing the work as well. So you're right that the victim's motivations are complex, and many things might be happening. But what I can tell you is that empirical studies show that many times victims are after different kind of responses to the wrongdoer, after moral responses to the wrongdoer. No, as I mentioned before, they want to know what happened to them. They want to prevent this to happen to others. They want to send a message. They want to affirm their value vis-a-vis the wrongdoer. So they seek responses to the wrongdoing that acknowledge in a better way the circumstances of the wrongdoing and the correlative motivations that the victim has. And to give you an example, when you look at, for example, the recent litigation against Johnson & Johnson for the baby powder ovarian cancer kind of lawsuits, what you observe is that, I mean, the victims that have been interviewed in most of these lawsuits, they say they are not after the money, that they are after sending a condemnatory message, and that they are after Johnson & Johnson finally eliminating this product from the market and avoiding these kind of injuries to happen to people moving forward, right, in the future. Also, I think a nice recent example might be the LA judgment against Meta for addictive design. And so there, the jury imposed punitive damages of $3 million, and victims were celebrating the overall condemnatory message. They were not talking about money. They were celebrating the message and what the judgment means for Meta and for future victims, and not the size of the award necessarily. And so there are many examples where what you can see is that much more than the money is going on. And all these examples, I think, allow to capture that many times money is a secondary motivation. But you're right, other times it might be the first and only motivation. But when reprehensible conducts are at stake, more often than not, the motivation is much more than compensatory. And this is what empirical studies tell us. So I am looking at those studies and I am putting together those empirical studies with the social psychology and psychology of retributive motivations. And this tells me that compensation is not predominant, at least when there is humiliating, reprehensible, egregious wrongdoing on the other side of the equation.
Good, yeah. No, and then the other thing that I think about when I'm thinking about these sorts of cases would be, I mean, can we really treat corporations or groups more generally as being culpable for wrongdoing? Like, does retribution really make sense there when not specifically targeted towards, like, in particular individuals like executives or people within the companies that might be responsible for the wrongdoings?
Well, again, I think like the Meta case example is a very good one. You can think $3 million punitive damages means nothing or very little for Meta in economic terms, but the decision is still consequential. And so it's about the victim having the legal standing to subject Meta to the jurisdictional power of the court to impose a punitive sanction. It is about allowing, for example, juries and judges to frame Meta's behavior as unacceptable and condemnable. And so it is, in a way, respectful to this need to have an avenue for expression of the significance of the wrongdoing and to express societal condemnation. And so I would say that there are many examples that actually are showing, in a way, what you're saying. Perhaps the amounts of punitive damages are not enough in economic terms, but so they're not moving the needle in economic terms, but yes, in terms of the message that they are sending. And again, let's don't forget that relational retribution is not only about the punishment in deservedness terms, but also about the value affirmation of the victim. And so these victims feel that they can claim their dignity if they can make the case for the court to impose a sanction. And that's why I emphasize so much the recognition idea, because the recognition idea, I think, is what explains many of the questions that you have on whether does it really make sense to punish a corporation and not when you're not talking about the individual persons and so on. And I would say yes, because all these other elements are involved. And perhaps just to close this thought, there are also empirical studies which are very interesting because they show direct evidence that actually individuals expect much more from corporations than from individual persons, because they expect to hold corporations to higher standards because they are experts, because your expectation of competence and knowledge is higher than of an individual. So this is what helps build this idea of there is a breach of trust when, because of your knowledge and your competence, you fail me as a consumer by putting a product as safe when actually it's harming me. No? So I think these are interesting insights against corporations and how retributive motivations work against juridical persons.
Yeah, okay, that makes sense. I could see someone trying to maybe push back and say, like, well, but corporations aren't really like agents in the relevant sense. They're not individuals that we would normally think as being potentially culpable of wrongdoing. It's individuals, it's like people and so on that are normally culpable of wrongdoing. Why? So what do you think about that? Do you think that's just wrong and it does make sense to treat corporations as well in that way, or groups generally?
Mm-hmm. Yes, thank you for that. Because also one of the objections is, well, you cannot punish corporations retributively because they have no ability to suffer, they don't feel pain, right? So this is another common criticism on why retribution might not make sense in the corporate context. But still, I think that when you look at what you have to identify, for example, for punitive damages to be available in the corporate context, is not the intention of the corporation. What you identify is the scheme of conduct, the policies that the corporation is putting forward or enforcing, the scheme of deliberate conduct that it shows that this is an invasion in a humiliating manner against the consumers. And so you look at, for example, the insurance policy, the insurance companies' policies of denying coverage to people consistently just for profit. And so you don't need to get into the subjective state of mind of the corporation or the subjective intentions of the corporation, but identifying whether the actions of a group are reprehensible. What do they say regarding the consumer? And you can reconstruct that in a very, very similar way as you do with individuals. And so once you take the subjectivity and the intention and the idea of pain out of the picture, it makes much more sense on why still it makes sense to, at least in my view, to punish corporations through the tort context. And perhaps the last, if you are not, or some people are not still persuaded, another, I think, aspect that I think is important to consider is that the criminal law is very bad as grasping juridical persons, right? And so tort law might be doing a gap-filling role in these kind of cases where any other areas of the law will be reacting to these kind of reprehensible practices. And tort law might have here a very important, if you want to call it, gut feeling role to play, when the criminal law will probably not be able to grasp this kind of reprehensible wrongdoing.
Good. I did want to ask also, because you mentioned this earlier, and it does come up in the book and towards the end, about like potential like AI harms, and as technology progresses, because you can have AIs driving cars, and that can result in problems, or AI in medicine and so on, in other cases like that, and maybe cases where we might even think there's kind of no fault at play. How do you think we might approach that in tort law, in particular with retribution or punitive damages?
Mm-hmm. Yeah. Thank you for that. I think this is chapter 8, where I suggest there are future avenues of research in connection with AI and new technologies, particularly in the context of product design and prox liability litigation. So the examples that you are mentioning are the examples I'm thinking, and there what I think is that I think punitive damages might be helpful here. Not only as a vehicle for expression of condemnation of reprehensible behavior and value affirmation of victims, but also as a complementary avenue for the generation of knowledge and meaning on which AI risks are unacceptable or acceptable to impose on others in our society. And what I'm saying that is because I care a lot about what I mentioned at the very beginning, the institutional value of tort law. And I think in the context of AI harms, where what predominate is uncertainty and opacity, I think we should start thinking of institutions that are going to help us to develop more knowledge about what is going on in these kind of cases, right? And so we are in a situation where regulators have not enough resources and information in order to grasp AI harms. Tort law can provide some knowledge through the tort process. So I'm thinking of, and this is the research that I'm working right now, on a more feedback loop relationship between torts and regulation, and how torts as an institution that can create knowledge and meaning through the imposition of punitive damages or through the impositions of other damages. But of course, my focus is on how punitive damages can enable these kind of processes, might help us to address AI harms and propose us on how to move forward with these kind of cases. So this is what I would like to do, and I think that punitive damages might be very helpful in creating knowledge and meaning in these kind of cases, and helping regulators and other actors in moving forward.
Good. Yeah. One thing I was thinking about this sort of case was that it's not so hard for me to imagine that as AI systems become more embedded in our everyday lives, and especially as they become more like agentic, I could imagine people having more of the retributive intuitions and motivations against these sort of AI systems themselves, and not just like the companies responsible for them or the regulators and so on. I don't know if you have much thought about that, but does that seem plausible to you that it would go that way? And like, what would your response there be?
Yeah, that's an interesting thought. I haven't thought exactly about developing retributive motivations against the AI itself, but this might be a good starting point to think about that. And I would be thinking on how to channel these kind of responses, no? Because I mean, once again, I think it's something that is very important. For the book and for me and for the theory is the importance of institutional channels. And the worry behind the book is that if we don't have institutional channels that are appropriate, then we should get worried, as you very well say, because, well, we might develop these retributive intuitions against AI, but does this make sense? How can we think of ways of channeling them in a way, once again, that we can control them and that we can filter when they are proper and when they are not, when they are rational, if you want to call it, or when they aren't. And I think this is what I'm thinking in the context of AI, how to channel these. I don't know if I answer your question directly, but I would try to think on that, how to control them, channel them, and understand them. And I think your point is very interesting because, again, coming back to the very beginning, I think we should try to grasp if this is happening. Let's understand it first, instead of saying no, we should ignore them, we should reject this shouldn't be happening. Perhaps, but first, let's try to grasp why is this happening. And sometimes one of the reasons is because there are no institutional channels to channel them, or avenues to expressing or channel them. So those are, I think, the elements I will be thinking about.
Yeah, no, that's very good. And I suppose we could also say, like, that's part of what helps. That's part of what this sort of theorizing can help with, is in trying to figure out where these sorts of intuitions and motivations would be appropriate, and that might generalize to new cases. I mean, there might be new cases where it's not like we maybe our theorizing hadn't covered it adequately, but maybe that's part of the upshot of this sort of analysis, is that it can help us think about it, maybe help develop the channels for addressing these sorts of cases as they come up. Because to me, it actually doesn't seem that implausible that the things could go in this way. But then that gives us a chance to develop this way of conceptualizing or thinking about it more that might be able to handle that case, and just sort of start to preempt that potential outcome before it comes, if that makes sense. But yeah, I did want to, so before we wrap up, I wonder what you think some of the lessons we can learn from this theorizing here. Like, do you have any sort of more specific proposals for tort reforms or modifications to the systems that we already have, or what do you think?
Yeah. Yes. I don't talk a lot in the book about tort reforms in concrete, because one of the aspects of the book, of the goal of the book, is to offer a theory that is cross-jurisdictional. And so this is why I don't dig deep into particular systems and into particular designs, institutional designs. But of course, there are things that I think come at different times in the book, and it has to do a lot with, for example, the quantification of punitive damages. And so there, empirical studies show that jurors are very good and at identifying reprehensibility. And so there is like a remarkable high degree of moral consensus on the behaviors that are deserving, in a way, of punitive damages, but they are very bad at translating, or they struggle at translating reprehensibility into amounts of money, right? And so there, what we could think as reforms is, well, perhaps we have to work on providing better jury instructions on how to handle quantification of punitive damages. For that, we should give like concrete factors that they have to consider, and this is what I tried to do when I developed the idea of proportionality in the book, and say, well, we have to look at the reprehensibility of the defendant's conduct, but also at the wealth of the defendant. And this is something, for example, that is not happening right now in the courts. And so this, I think, it would be something worth thinking, offering ways of quantifying punitive damages that can close that gap between in translating, reprehensibility to amounts of money. But some other kinds of tort reforms that I have in mind is, because I mentioned, to me, the value of the tort process is very important in the theory. And of course, there is a lot that we can do to improve it, to improve not only the access to justice, the cost of the systems, the time, and how time consuming it is, but also more concrete changes or proposals into how to overcome the power dynamics, the structural dynamics in discovery, especially in the mass market context, right? When you have a manufacturer and a consumer, how to counteract this so we could really use the thought process as creating knowledge and meaning, which is something that is very important in the theory. And there are a lot of scholars that are working on ideas like the knowledge remedy, on how to put, for example, the cost of discovery of certain facts into the defendant, and so on. So there are a lot of proposals that I haven't developed, but I want to continue developing, that had to do with not only to improving how we apply punitive damages, but also how we should think about the tort process, how we can make it in a way that can help us enable the tort process to be this knowledge and meaning creating tool. But yeah, I had to think of more concrete examples in each jurisdictions that I haven't done quite in the book, but I would like to do more in the future.
Yeah, and I could definitely see that as there's a lot more that could be explored along these topics, and in particular jurisdictions. But yeah, so I did one more question before we wrap up, or two more questions, I guess. What would you say is the core conclusion you want people to draw from this book? How would you sort of summarize the main conclusion you draw?
Yeah, well, I would say punitive damages are about much more than the money, and they're telling us important things about tort victims, tort law, and the tort process. And I think that would be like my main message through the book. And so they are an expression of the victim's agency and equal value. They are an avenue for expression of condemnation, of reprehensible behavior. They are an avenue of expression of the significance of the wrongdoing. So they are much more than amounts of money. And they tell us tort law is much more than a mechanism to achieve ex post compensation to victims. It is a meaning and knowledge producing institution that has the potential to catalyze change and regulatory action. And tort victims are no longer passive recipients of wrongful behavior seeking compensation, but active participants in the construction of other regarding meaning and knowledge in our society. So yeah, this is what I would say is the message that I would like people to understand of the book.
Oh, great. Yes, that's very well stated. So yeah, I do normally end with a more kind of general metaphilosophical question. So what do you think is the value of philosophy, perhaps more generally, or with legal philosophy in particular? What do you think?
Yeah, well, I think it's very important. I think basically what attracted my attention to punitive damages from the very beginning was the tension and under-specification of this declared function of retribution and deterrence, and how these transpire everywhere in the scholarly treatment of punitive damages, in the Supreme Court decisions on its imposition. And so when I look at the problem, it looked like there was nothing new to be said about punitive damages. But when I started trying to challenge what those concepts really meant, and when you start being willing to engage in a much more robust theoretical conversation on these underlying fundamental concepts that look like settled, retribution and deterrence, then you start grasping the broader implications, and you start understanding that there is a lot to be said, right? And so even myself, I was surprised how this kind of philosophical reflection on the underlying concepts led me to rediscover tort law, led me to rediscover or reimagining tort victims, and led me to also rediscover or thinking of the tort process in a completely different way. So I have to say that punitive damages and this particular book, I think, are an example of why legal philosophy is so important. It's really important. There are conversations that we thought they were over, and there is a lot to be said. And actually, what I will hope from Torts and Retribution is exactly to renew the conversation. And I think that legal philosophy can do that. once you bring to the fore different understanding of these concepts, once you unpack these concepts in a different way, you spark a new conversation. And I think legal philosophy is key in doing that job. So, yeah.
Right. Yeah, that's a good summary. So, and I'll include links to where people can find this book on Cambridge University Press or Amazon and so on in the description.
Yeah.
But there it is. Yeah, it's a great book, and thanks so much for coming on, Maria, and taking my questions and providing your thoughtful responses. It's been really great having you.
Thank you so much for having me. I really enjoy it. Thank you so much.